Testing 1 2, testing 1 2. Testing 1 2, testing 1 2. All right. All right. There we go. So why is this now not popping up? That's beautiful. Now it does not want to show up. Let's try this. Okay. Thank you. Bear with me just a few seconds, and we will be starting. Oh, really? That one's not leaving. All right, there we go. All right, everybody, what's up? Today is Supreme Decisions, and tonight I want to talk about, actually it's 12 in the morning where I'm at, but I want to talk about something that people have been asking because I started back doing the bad cop because the Giglio information or the Brady list that police departments are supposed to keep and the defense attorneys, or excuse me, the prosecutors are supposed to be sharing with defense attorneys, whether they ask or not, they aren't doing. But we're trying to figure out exactly how that you're able to get this information. Now, if you come to me prior to your case, I'm going to give you a detailed discovery with 90% of this information in it. But I, again, feeling a little magnanimous. And I'm offering you a kind of a peek behind the curtain of, again, your defense whenever you're laying this together, because most people don't think that they can actually go after and get the credibility of the police officer and question it. Because, most time whenever it's just taken at face value. Why? Because it's supposed to be an honest profession. Whenever I told you that police officers aren't able to tell the truth because they are using stock language, and stock language does not allow for them to be truthful, which is one of the reasons why you challenge everything. So tonight, we're going to talk about getting the police officer's information prior to your cases and basically going over their prior bad acts. Now, when you are a defendant in a criminal trial and the officer's testimony or the police report is a key part of the prosecution case, exposing the officer's prior bad acts and misconduct or credibility issues can be a powerful defense tool. Why? Because now, just like the first thing they do when they arrest someone, they go out and they talk about how this person was, just like what was Amir Locke. They couldn't use that against him, so they just actually just stopped talking about it. Because Amir Locke was, oh, he had a gun because he could have a gun in his own apartment when the police went into the wrong apartment and then lied about why they shot him and killed him. But they could not use the fact that he was a bad person because he was a hardworking young man who had just graduated high school. But at the same time, that's the first thing they bring up. They bring up, oh, well, this person in the past had been convicted of this. This person in the past had been arrested for this. This is our opportunity to say, in the past, this police officer wasn't able to follow department policy. Why do you think they're able to do that here whenever they don't have that type of supervision? Now, courts generally follow the rules of evidence, like in Federal Rules of Evidence 404, 608, or 609, that limit character evidence, but there are exceptions that allow you to use the officer's misconduct if it relates to the truthfulness, bias, or credibility. Now, I just did a video that a lot of people had an opportunity to see where I pointed out bad cop. This young man had 72 total complaints, generally showing bias because he was biased towards, or he has an affinity towards someone with darker skin. And his credibility is because he's lied in several instances, which is why he has 5 now false arrests. And so therefore his truthfulness is always in question. And even whenever I put up the young lady from Richmond County, she has a truthfulness issue. Her credibility is trash. So anytime she's involved in the arrest, you then challenge her arrest. Now, here are ways to obtain records and use them. Now, you have Brady versus Maryland and Giglio versus United States, which require the prosecutors to turn over evidence that is favorable to defense, including prior disciplinary findings against the officer, lies, falsifications, or credibility issues in reports, bias, misconduct, or corruption. All of these, again, are required by the prosecutor to turn over to the defense. Now, one of the ways that I kind of take that off the table for the prosecutor to say, oh, well, I didn't know, is you create an actual detailed discovery in which the officer's information is requested in there, not just the police report, not just their Giglio information. You also go deeper into it because, again, you're challenging everything. So you put what's necessary in the request. And that way they can't say, oh, well, I didn't know. And then if they don't turn it over, it then becomes a blatant Brady violation because the prosecutor are not the ones that can make the decision on what you can and cannot have to prepare your defense. Now, as defense counsel, whether you're pro se or you hire someone, you can file a Brady motion or request a Giglio disclosure to force the prosecutor to reveal if the officer has impeachment material in their personnel file. Now, because you also remember, one of the things they don't have to turn over is issues in a personnel file. However, if they're using the officer's testimony or they're using that police report, which 90% of the time they do, as a means for arresting and charging you, you can then go after that officer's character. And this is, again, through motions. Now, in California, this is a state-specific motion. It's not necessarily called a detailed discovery, but a pitchness motion. Pitchess, pitchess motion. if you want to break it down, keep it simple for you. In California and some other states, you can file a petitioner's motion to request an in-camera review of an officer's personnel file. Say that again. You can file a motion, a petitioner's motion, to request an in-camera review of an officer's personnel file. If the judge finds relevant complaints, i.e. dishonesty, planting evidence, excessive force, they may release them to the defense. These are things, again, which empower you with the ability to actually defend yourself and go after police officers that are out here doing things that are against their oath and against the actual duties of the office of police officer. Now, you often see this, because I spoke about this before whenever I spoke about how to get information off a police officer's phone. And that's through a FOIA request or a Freedom of Information Act. Now, you also have state-specific acts, because even like Louisiana, it's not called a Freedom of Information Act. I forgot what it's called, but I literally just filed one last week. I can't remember what, but they actually have a state-specific, just as California, request for records. And the State Public Records Act, and that's part of Louisiana. The State Public Record Act requires you can request records from police internal file, civilian review boards. Did you catch that one? Civilian review boards. Because, you know, the police are the ones that are policing the police. Which is why you don't see punishment, because most police officers don't see a violent act. They see good police work. And they don't understand that not telling the truth isn't a lie unless it's a suspect that's doing it. Because if a police officer does it, it's just good police work. That is also something that you can use against them. Because the Civilian Review Board, 90% of the times, they're acquitting officers or excusing the behavior officers, which opens the door for federal lawsuits and state liability. But I'll get into that later as well. Prior lawsuits or settlements involving the officer. This is one of the reasons, again, I put that information up for a couple of officers, because you had an officer that had cost, I believe, the city almost $2 million, and he was still working. He was laughing about the murder of a young lady, talking about, oh, well, she's only worth $11,000. But this dude is constantly in trouble. He can't even follow department policy. So again, if he makes an arrest, make him worthless by challenging everything that he does, because his credibility is trash. Now, while personnel records are often exempt, sustained findings of misconduct or prior complaints may be available. But again, they're not if they're not properly requested. And I keep using that word because I even used, I did a video literally, I want to say about a week or two ago, how not to hire me. And the thing is I went over mistakes that people generally make, and it's not doing the request properly. Because again, it's one thing to know how to request it. It's another thing to know how to enforce that request. And again, separate actions and separate understandings. And most people don't know. And again, the verbiage. These are things that I hate to say it like this, but you're speaking almost a different language, because if you go in with today's English or grammar that we know, it's not going to fly in court, and they're able to ignore it. Now, if you're using the proper court grammar and the proper court etiquette, they then have to abide by their own rules, and their own rules force them to play the game that you can now master. And even within that, the biggest issue that we're going to have is make sure they stay on task. And that's a different aspect of this whole situation. Now, prior civil lawsuits or complaints, this is where you're going to check court documents. Now, it'll generally be in probably your vicinity of federal courts. Now, this is a little bit more intricate, not required, but you can go down to the courthouse, do a quick search, or pay somebody $20 to do it for you. Now, you can check court documents for civil rights violations or lawsuits. The easy will be the 42 U.S.C. 1983 claims that are against the officers. And if the officer was a defendant in a civil case involving false arrest, which the last bad officer I put up was in Chicago, excessive force, which he had, I believe, 27, or dishonesty, which he had 20 of those can be used to impeach the credibility. Again, the dude that I put up has no credibility. His credibility is trash. And even one of the most famous is Mark Harmon with OJ. It just so happened he was the one that found the glove. The problem was he was the dirtiest cop that could have found that glove. And it was one of the things that Johnny Cochran allowed to come in spite of it being suppressed. Which, it's again, that's one of those things that you can play with. But understand, when you start playing the game, it is chess. And what he did to me was a big gamble. But he saw something that I didn't see even, rewatching the trial. Because I was kind of young when it happened and I didn't really care that much. But as I got older, I rewatched it and I was like, that was a big move because I wouldn't have done it. Because it was, to me, an unnecessary move. But anyway, the cross-examination on bias or dishonesty. Now, under FRE, Federal Rules of Evidence, 608B, or the state equivalent, you may be allowed to question an officer on specific instances of dishonesty if relevant to credibility, such as falsifying reports. Now, this is one of the reasons why I put up dates. If they're available to me, these are the things that actually go into the context of maybe I don't know the specific dishonesty portion, but if I go to that date and I ask for that reports from that date, I can actually show the dishonesty. Even when I spoke about the fact that if they're using multiple police reports, that again shows the dishonesty, the ideas and the willingness to be deceitful for the most part. And the biggest issue on that is doing it in front of the jury. Now, one of the things that I also did, because I did this during the RICO trial, and Officer Johnson, I don't remember his first name, but it was Officer Johnson. My brother's attorney told me, hey, you need to object because he was talking. And I told him, I said, no, let him talk. So when he was out there talking, I went to cross-examine him. One of the things that caught everybody's attention was the fact that I had him admit to 4 lies. It was almost like some TV type stuff because I asked him about a warrant that he had mentioned. He mentioned the warrant. So I asked him about a warrant. I knew he did not have a warrant. So whenever I made the request of it, so where did you get that warrant that you spoke about? He's like, oh, I didn't have a warrant. Okay, so you misspoke. Because if you call someone a liar in front of the jury, it is distasteful in most instances. But if you point out that they're constantly misspeaking, that takes away from their credibility because one lie destroys 1,000 truths. Always remember that because, again, it's a tactic. Because I actually did that 4 times. I didn't call him a liar. I just pointed out the fact that he misspoke several times. So you have a habit of misspeaking, or you just got excited in the moment. And see, either way he answers that, he's a liar. So now his testimony is out the window. And this is what you're trying to do when you're getting this information. Because even with officers with prior criminal convictions, They say it's rare, but it's possible. Just like the New Mexico officer, because actually I've been putting up a lot of in the post, in the community post. I'll put up the officers and I talk about the speed, because generally the officers are going, when they're stopped, they're traveling at speeds over 100 miles per hour. Looked at one of the police officers, one of the Texas officers. She actually had killed someone in a hit and run. She was traveling at over 100 miles per hour while she was off duty. New Mexico cop was going to work. He was in full uniform. He was drunk and he was traveling at over 100 miles per hour in New Mexico. And these are the things that are admissible. Why? Because it shows that they are bad actors for the most part. Because again, if you're driving inebriated, isn't that technically what you're not supposed to do? As a police officer, as law enforcement, you're not supposed to actually break the law. But anyway, and these their criminal record, just like ours, can be brought in. Now it's a little bit more difficult, but under the same Federal Rules of Evidence 609, you're able to actually bring those in. Now, one of the things that I found has been the new tool is subpoenas, because they really don't like turning over information. Like, no matter what you do, they don't want to turn it over, because they know once they turn it over, the case is over with. And the money starts to look different for those that are fighting against them. So the defense can issue subpoenas for internal affairs records, prior disciplinary action, even police academy performance records, but if that's necessary. Now, just to give you an example, I spoke about a friend of mine who went through the Georgia Academy. Georgia Academy is 6 weeks. It started out with, I think she said 360 some odd people. They ended up graduating a little more than 300 people. And that's because most of the people quit in 6 weeks. And not because they actually failed. Because she actually told me, if they actually went by the people who passed, you're talking about less than 30 or 40 people out of almost 400. Because the majority of the people could not pass the written test and couldn't pass the physical test, which is why Georgia is one of the worst places for police officers. Now, when you're doing that, those records become relevant. However, do you really want them? Because they're lying most of the time. But you do have people that have repeated the academy multiple times. What was the reason for it? Now, there's a multitude of reasons why someone could or even would repeat. But again, it doesn't really matter. And the impeachment with inconsistent statements. Now, this is, again, what I spoke about the other day. Compare the officer's arrest report, testimony, deposition, or prior case testimony for contradictions. That's one of the things I, again, just spoke about. If you have a police report that's written, because, again, this is why they hate paperwork. You have a police report that's written one day, you're able to get that generally within the week, within 7 days, sometimes 10. But then they see that you're actually going to challenge it. So what they'll do is they'll clean that report up. So now you have a second report. That is a consciousness of guilt, because they're going to rewrite that report. In that report, you're going to have inconsistencies. Why? Because stock language does not allow them to be honest. Yes, I pause for dramatic effect because I want you to understand that. I don't just say these things so they sound good and it's pretty. There's a reason that I'm telling you this. Hell, that's the reason why I'm actually doing more of the live shows, because I want you to understand there are different opportunities and there are different options now. And inconsistencies can be introduced at trial to challenge credibility. And this is why, again, I'm giving you piece by piece, line by line, precept upon precept. Now, here's the thing that some people use. I have never used it. However, it's a tool. Because again, law is a tool, knowledge is power, but application is the ultimate fight. Anyway, in some cases, experts can testify about patterns of misconduct in departments or among officers. Now, police practices experts who explain, test the line, or report falsification or fabrications. This is one of the things that if you're in LA and you're arrested and you are not challenging police credibility, if you're not challenging the police report, if you're not challenging evidence, whoever your attorney is incompetent. And I'm saying that with the utmost confidence. If you're in LA, California, Los Angeles, and you are arrested in LA, Los Angeles, California, and your attorney is not challenging anything that's coming out as far as an arrest with any of these cops, your attorney is incompetent, because this is one of the worst places in the country for this. They have a heavy practice of not telling the truth in reports. Their body camera never matches what's in that report, ever. I've yet to see it. And yeah, I've yet to see it. I've actually looked at literally hundreds from LA, just LA. I've never seen them tell the truth. Their body camera footage never matches what they write in those reports. So that is the one thing, again, that is the pattern of misconduct, because it's not only allowed, it's encouraged and it's trained. I'll say that one more time. Not only is it allowed, but it's encouraged and it's trained. So the key for this is you don't usually get to use bad character evidence just to show the officer is a bad cop. However, you can use prior bad acts of dishonesty, bias, falsifying reports, or excessive force if they directly go to the credibility, motive, or truthfulness of the police officer and your case. Always remember that. This is why you call for the consultation, to make sure you have a case. And even in the context of that, you want to make sure that you are doing the right thing at all times and you're going in the right direction. This is one of those instances in which the right direction is not only the best thing for you, it is the thing that gets you to where you're trying to go. So remember, you can challenge police officer credibility. When I spoke about challenge police officer character, these are the things that I'm talking about. Always understand this is an option. Make sure it's done correctly. And that's why I'm saying, hey, let me give you different options. You got to contact me on you can contact me via email, greatestnow@yahoo.com. And you can set up actual phone appointments and under Calendarly, the GOCP, for 30 minutes. I have 30-minute consultations. So always understand that. Just hit the link. It's as simple as it can be. We can set them up as quickly as within the next 12 hours, because I literally have 12-hour blocks. So it's from 9 to 9 on the East Coast and 6 to 6 in California. So 6 a.m. to 6 p.m. in California, and everybody else got it in between. They're literally a 12-hour block that I have set up just for consultation, so people know if I have a case, what direction we can go in, and how we can get this job done. And you can do the challenges the right way to get your case not only heard, but actually taken care of in a manner in which you want it to be done. So thank you guys. I will be back on again. I'm not going to say tonight, but it'll be in the morning. So holla at your boy, Supreme, and I'm out.